Labor appears to be moving towards supporting this legislation, and have managed to, it appears, to extract some concessions on protecting journalist sources. Just on that issue alone, protecting journalist sources, do you think the new arrangements go far enough?
No, I don't think they go far enough, and I'm not even sure that the government's managed to persuade the Labor Party, because of course nobody has seen these amendments yet, and I suspect they'll be quite complicated to draft, because you can't protect people if you don't know who they are. So it may be that a warrant would be required to grab the private information or the phone records of a journalist, but how do you protect people who might be communicating with that journalist? You could go through a whole, like a small government department and identify everybody in there and everybody they've called, and if the names, if the phone numbers of journalists come up, getting a warrant then is kind of moot. So I don't think these amendments go far enough, and if anything, it demonstrates the swamp that the government's dragged us into with this bill. Because
the whole idea of mining this metadata is to collect a large array of data and then sort of distill it down. That's how it works, isn't it?
Well, that's how it's proposed to work, and it's a very similar mindset to the US National Security Agency's motto of collect it all, which was revealed so vividly by Edward Snowden, and now we're seeing that playing out to a degree here in Australia, where rather than going after suspects or networks or persons of interest, the idea is that we'll collect the private information of 23 million Australians who aren't suspected of wrongdoing at all, and hope that we find the needles in that much larger haystack.
So let's explore that scenario that you've just set out there. Say there is a leak from a government department to a journalist, the government isn't happy, it calls in the AFP, they mine the data and go, hello, here's some people who have been contacting journalists.
Yeah.
As you understand it, is there anything in these proposed laws that would prevent that from happening?
There's nothing in the proposed laws that would prevent that from happening, but more importantly, that's the status quo. That's the broken system that we have at the moment. And Senator Brandis, the Attorney General, was on TV this morning making that point, and he's quite right. The system's broken, and the government, potentially with the support of Bill Shorten, is proposing to add vast new stores of data to a system that's already fundamentally broken.
And if we take that scenario further, if the government goes, OK, we know what's happening here, we think we know what's happening, they go and seek a warrant, what guarantees are that the court will say no?
Well, this is why it may be that we adopt a situation similar to that prevails in the United States, where the warranted process itself is contestable, that people can actually argue that communication should be privileged and shouldn't be accessible. But it does belie the point as to why this government is so obsessed with tracking down journalists and whistleblowers at all. And this is happening, we're seeing it quite starkly in the instance of people doing public interest reporting on the horrors of our mandatory detention system, that when reports get into press, the government immediately shops those reports and the journalists to the federal police, who are then charged with finding out who's talking. Now, these revelations are in the public interest. We have quite strong shield laws protection to prevent journalists from being dragged into courts to disclose their sources. But the way that warrantless access is occurring at the moment, and would continue to occur, is that the shield laws are completely circumvented. Agencies are just going around to find out who's talking to who.
And so there may be some sort of protection for journalists, but the sources, really, that's your fear, there's no real protection for them here.
Well, it's difficult to work out how you could do that simply through modifying the access regime. The deeper question is whether we think it's appropriate for the government to be going on these witch hunts in the first place when people report stories that aren't popular with the government of the day.
OK, now there's another issue about who is and who isn't a journalist. I mean, 20 years ago it was probably pretty obvious who was a journalist and who wasn't.
Yeah.
But there's a definitional problem there now, isn't there?
Well, not necessarily, because the definition that we got into the Evidence Act a couple of years ago when we were debating shield laws is deliberately quite broad. So the definition in Australian law at the moment doesn't depend, for example, on you making money out of reporting. And it's quite a common sense, plain English description of people who do news gathering and might come into contact with sources. So Senator Brandis doesn't think it should cover bloggers. I strongly disagree. whether you're making money from your reporting or not, if the reporting's in the public interest and you need to protect your sources, then it should be protected.
But he's the Attorney General. If he says it doesn't cover bloggers, well, what come back to Parliament?
Well, he hasn't read the law. I mean, he hasn't read the statute. So I kind of can't help him with that. He's meant to be the Attorney General. The definition in the Evidence Act, I've got a copy here. It's quite black and white. It's quite a broad framing of journalism, and that was deliberate.
Well, what happens, though, if, say, the AFP or an intelligence agency does collect the metadata of a citizen journalist and then goes, oh, look, sorry, we didn't realise that they were a journalist?
Yeah. This is the swamp that the government has dragged us into. The idea of an indiscriminate surveillance regime being welded onto a system that's already broken, where those protections simply don't exist, is precisely the problem that many people have been pointing out for months.
Does it concern you that while Labor is trying to work this concession to protect journalists, that other people aren't protected, including politicians? I mean, whistleblowers, the media is one outlet, but politicians are another.
And let's not discount the fact that raising the bar to provide for warranted access to journalists' metadata isn't a backward step. It's not a bad idea. It's just that it's really circumvented by all these other things. Politicians are meant to be protected to a degree by parliamentary privilege, where it's actually quite a serious offence to interfere with a parliamentarian in the course of their work. But what about diplomats? What about senior serving military officers? What about doctor-patient confidentiality? What about legal professional privilege? It's a massive can of worms, and I would be immensely disappointed, as I suspect many people will, if Bill Shorten backs Tony Abbott on this misguided initiative.
Just finally then, given all these concerns that you've set out, and I imagine that some of those concerns will be shared by some members of the Labor Party and probably by some members of the government as well.
Yeah.
Why do you think Labor is so ready to do a deal on this where they haven't been ready to do a deal on a whole swathe of other policy issues?
I think it's a good question. I think in Australia, traditionally, what we've seen is as soon as the government of the day of either side mentions the words national security, the opposition is just meant to fold and not provide any critical thinking. Now, we saw that last year with the ASIO bill that effectively criminalised national security reporting. I'm glad that at least there's been a degree of critical thought applied to the metadata bill, because it's obviously much wider than just national security, before the vote rather than after. But as to why, in their right minds, Bill Shorten would throw Tony Abbott a $400 million surveillance lifeline to try and rescue his failing prime ministership is totally beyond me. We need an opposition. This government really deserves a strong opposition, and they're not really getting it from Bill Shorten at the moment. So all I could say to the Labor Party or to those members of the backbench or their spokespeople who are concerned is slow this down. The vote certainly shouldn't proceed next week. We should wait until after the Joint Committee's been given an opportunity to do its inquiry.
Okay, Senator Scott Ludlam, thanks for your time today.
Thank you.